Despite the efforts of Michael Latham and John Egan, construction remains a fairly fractious industry. However, whereas disputes were commonly dealt with by the courts, nowadays parties in disagreement need not become embroiled in lengthy and costly legal battles to sort out their differences. Alternative dispute resolution, or ADR, is often characterized as a speedy, informal, inexpensive way of resolving disputes. Whether that's true or not, over the last 35 years, the industry has seen a boom in this alternative to formal litigious proceedings. Mediation, conciliation, arbitration, and adjudication are among the more common forms of ADR used to settle construction disputes. And I'm delighted to say that joining me today to talk about ADR is a man often referred to as the father of dispute resolution in the UK construction industry, Roger Knowles. Welcome, Roger. Thanks for coming in.
Thank you very much. Nice to meet you.
Pleasure's all ours. Roger, if you can, just briefly, could you just give us a synopsis of the various forms of ADR available?
Well, there are quite a few, but there are four main ones. The first was arbitration, then there's mediation, adjudication, and conciliation. Arbitration, whilst it's traditionally referred to as ADR because it was a very informal system at one time, has now become far more formalised, and it follows the court procedure almost, because we have rules of procedure which tend to follow the court process, involving each party submitting their case in a pleadings form, full research of all the case, then we have a full-blown hearing with witnesses, and then ultimately we get the decision. So that's how arbitration tends to work now. Mediation is a complete opposite, because there's no structure at all to mediation. You appoint a third party whose job it is to act as a facilitator to get the parties together over a period of maybe 1 or 2 days and to come up with a decision whereby both parties reach agreement. The agreement is signed off in a formal fashion, and that is enforceable. Adjudication, well, that came into being in the 1980s. And the idea was, again, it was an informal system. A decision was made, and you had 14 or 28 days to accept it or to reject it. But with the Construction Act, which came into operation on the 1st of May 1998, this is now a statutory method of resolving disputes. But the difference between adjudication and the others under the statute is that it's to be carried out in accordance with a very strict timescale. So once you've appointed the adjudicator and the referral has been submitted, the decision must be made within 28 days. So that's a very strict timetable within which we all have to operate. And finally, conciliation. Well, again, it's a little bit like mediation. There are no ground rules, but the difference between conciliation and mediation is that the mediator does not give an opinion or a decision, whereas the conciliator will make a recommendation or will come up with some suggested decision, leaving it for the parties to either take it on board or to reject it.
Okay. What are the pros and cons?
Well, perhaps I could just start off by saying that over many years there's been dissatisfaction with litigation, mainly on the grounds of time and cost. And if you're involved in commerce, you want to get your dispute over and done with as least fuss as possible and least cost. So people in commerce have been looking for an alternative way. If you go back a few centuries, that was when arbitration first became popular. And in those days, it was very much the look and sniff approach. If perhaps you were dealing with a commodity, you were buying corn and you weren't happy with the quality, you were able to send your messenger around to get the arbitrator to come and make a decision. He'd do a bit of looking and sniffing. He'd make a decision whether the corn was okay or whether it was substandard, and that would be the end of that. In construction terms, if there was a question about the quality of the work, you could perhaps get an arbitrator who was an architect to pop down, yes, approve the joinery, or perhaps say it wasn't up to standard, and that was the end of that. But in the 1900s, I think the legal profession, realizing that a lot of work was being taken away from the courts, started to become interested in arbitration. And they started to bring with them their formal procedures. So after perhaps a period of time, the arbitration process began to mirror image litigation, with all the problems that we had with litigation, delays and additional costs. So the industry, construction and commerce in general, were looking for an alternative way. And the missionaries came over from the USA in the early 80s, the mediation missionaries said, well, what you guys want to do, you want to get your disputes resolved by mediation. And the idea of mediation, it's win-win. You don't have a winner and a loser. And so with a win-win situation, everyone goes away happy.
Can you just explain this kind of difference between ADR and litigation, first of all? Just kind of spell it out for us.
Well, I think with litigation, first of all, if you want to go to court, you have to appoint a firm of solicitors because they have a monopoly of presenting cases before the court. You have a procedure which is governed by statute going back hundreds of years. You've got very, very rigid procedures. You've got to make sure there's no possibility of any injustice, and so this all takes time. I think there are some people in the legal profession who seem to want just to spin it out. And also it's all for the convenience of maybe the QC or the lawyers involved, not to mention the parties as well, and this all really takes time. But if you're involved in an alternative dispute resolution approach, then there is less procedure in some ways, but particularly something like media, there's no procedure. It's left to the media to decide what the procedure is. He lays down a strict timetable, and you've got to comply with that. So we're overcoming the difficulties in litigation by being much more flexible and giving power to the third party who's running the show to decide how the show is going to be run.
But can you just explain who appoints the mediator or adjudicator?
Well, it depends. You can, of course, when you enter into your contract, you can write in the name of the person that you want to act as the third party, whether it's mediator, arbitrator, or adjudicator, or in your contract you can write in an appointing body. Traditionally, on construction projects, the RIBA have taken a very major lead in appointing arbitrators, adjudicators, not quite the same extent mediators, but they're very much in the foremost. The RICS the same, the Chartered Institute of Arbitrators the same. Mediation is a little bit different. It's fairly new, and if you want to appoint a mediator, well, you may well agree on somebody. But if you can't agree, there's an organisation called CEDA, that's the Centre for Effective Dispute Resolution. They specialise in promoting mediation, training mediators and appointing mediators. So you can either name it in the contract, you can have an appointing body, or you can reach agreement between yourselves.
Okay, so after the decision has been made in the ADR procedures, how is it enforced, especially if one party maybe doesn't necessarily agree with the result?
Well, if you take arbitration, there's a long history of courts enforcing arbitration, because if it wasn't enforceable, it would be a bit of a waste of time. So there's no great problem with having arbitration decisions enforced. Mediation, well, the mediator, he doesn't make a decision. He's there as a facilitator, and he tries to get the parties to come together to reach agreement. However, once he's succeeded in getting the parties to agree as to how the dispute will be resolved, it's essential that that agreement is committed to writing there and then. Don't let them out of the room before the decision is put in writing and signed by the parties. Once you've got that decision written up and signed, then that will be enforceable. Adjudication came into being following the 1996 Construction Act, and the adjudicator's decision will be enforced by the court via the summary judgment procedure. And no difficulty with that. In the early days there was a bit of arguments as to whether it was enforceable or not, but the court said this is the will of Parliament, that this is the method that the parties may choose to resolve their disputes, and therefore we're going to ensure that it's enforceable. So no problem as far as that's concerned.
So is it necessary in any of these processes to appoint a solicitor? And it may be worthwhile if you spell out the roles now of mediator and adjudicator, as you've mentioned already, but is there any responsibility or necessity to appoint a solicitor?
Well, if you're operating on ADR, no. If you go to court, you've got to be represented by a solicitor unless you represent yourself. You can represent yourself before a mediator, arbitrator or adjudicator. You could in fact appoint someone like James R. Knowles to represent you, or you could obviously represent yourself. A lot of the big organisations like to appoint solicitors. I think it's a bit of safety first. No one ever got fired for buying IBM, and some of them are very, very good and don't want to take that away from them. But you have total flexibility as to who you get to represent you.
Right. And if there is such a thing as a typical case in ADR, how much would you expect to see it costing, the whole process, and what's the likelihood of a successful party actually recovering costs?
Well, it's a bit like how long is a piece of string, and it depends how complex the situations are. But from my experience with James R. Knowles, the fees that we incurred with arbitration would average about £100,000. The fees we incur in adjudication is £10,000, so it's like a tenth of the cost to go to adjudication. With mediation, it can be even cheaper. It depends how you run it. But if you've got a dispute, you've both agreed to refer the matter to mediation, and a mediator is appointed who runs the show. The mediator will normally require the party to put in writing in a few pages what the dispute is all about. So that's not going to take very long and cost very much. Then you've got a day or two with the mediation. You're talking about some fees there, and you've got fees for the mediator. So again, £10,000 would certainly cover all of that lot, and you might get a bit of change as far as that was concerned. So arbitration, very expensive, adjudication, fairly cheap, and mediation even cheaper.
Okay. And you pointed out a couple of timescales there, but again, on average, what sort of timescales?
Well, I think if you were taking your case to court, you've got to think in terms of 2 years, and it could be longer. You might get lucky and get it done in 18 months. And arbitration seems to follow a similar pattern, although the CIR, that's the Chartered Institute of Arbitrators, have produced a 100-day arbitration, but I haven't heard of many cases where the 100-day process has been used. So you can think arbitration litigation, you're talking about a very long time. Adjudication, the Construction Act laid down that once you've served your adjudication notice, an adjudicator must be appointed and the referral, which is the claim, submitted within 7 days. And the decision must be made by the adjudicator within 28 days. So it's all done and dusted very quickly. If you're the adjudicator, you can get an extension of time for 14 days. And funny enough, I've had a couple of appointments this week. But beyond that, beyond your 42 days, that is it. You've got to make the decision. So it's all over very, very quickly.
Is that necessarily a good thing? Is that hasty justice?
Well, I think it's a plus and a minus. I think that if the dispute is complex, then I think that it's far too short. And I had one not too long ago where I had a dispute over a final account with 100 items in it. And each item had a load of measurements and figures. The main contractor had his version as to what the total should be, and the subcontractor had his version. Well, there's no way that I could go out on site and measure it all up to decide which of the two competing figures was right. And 100 of these, I only got 28 days. I did get an extra 14, but nonetheless, there still wasn't time to go and check it all. So I had to make up my mind which of the two figures in each case was the right or the wrong one. And that was a little bit rough and ready. I felt at the end of the day a bit of justice was done. Whether the figure was right or wrong, I wouldn't really like to say. But if it were a single issue matter, well, I think 28 days is long enough. But the courts have said, well, if you're not happy with the decision, then you can always subsequently go to court or arbitration, if there's an arbitration clause, and have the whole case heard again, in which case you might get a different decision. But most of the time, if you're talking about sums of £100,000, nobody bothers. If you're talking about more than £1 million, you've probably heard of the big dispute on Wembley Stadium between the main contractor and the company that erected the steel arch. Well, that went to adjudication, and we're talking millions now. And of course, the result didn't go the way of one of parties' aspiration. It then went on to court, and they took a different view, as it turned out.
Very good. Okay, well, let's just pause there for a minute and remind ourselves of some of the various different forms of ADR available.
ADR refers to all dispute resolution processes outside litigation where a third party assists in the resolution of a dispute. Broadly speaking, ADR can be grouped into 3 categories: assisted negotiation, evaluative methods, and adjudicative methods. Assisted negotiation includes mediation and conciliation, 2 similar processes in which a structured negotiation programme is managed by a third party to produce a legally binding outcome. Although becoming increasingly blurred, the main difference between the two is that in conciliation, the negotiator has freedom to table suggested solutions. Evaluative methods of ADR include neutral fact-finding and early neutral evaluation. In the latter, an evaluator gives his or her opinion as to the likely outcome at trial, and in the former, the parties decide in advance how they will react to a non-binding report on the issues in dispute. Adjudicative methods of dispute resolution include arbitration and, of course, adjudication, 2 of the most commonly used forms of ADR in construction. The Housing Grants Construction and Regeneration Act 1996 provides a statutory right to adjudication. The decision of an adjudicator is binding unless or until the dispute is finally determined by court proceedings, arbitration, or by agreement of the parties. Arbitration is a formal binding process in which the dispute is determined by an arbitrator or panel of arbitrators on the basis of a legally reasoned award. Although subject to challenge on limited grounds, the award is rarely subject to appeal.
So, Roger, with so much to choose from, how do disputing parties actually decide on which form of ADR best suits them?
Well, if they sign a standard form of contract, it's already laid down in the form of contract the dispute resolution method which will be followed. Traditionally, under the JCT form of contract and the ICE, the preferred dispute resolution system has been arbitration, but with the Construction Act, the parties can insist, irrespective of what the contract says, they can insist on having their dispute referred to adjudication, because the Construction Act laid that down as a basic principle. If, on the other hand, the contract says that the dispute resolution process will be arbitration, they can go for arbitration, or under the statute they can go for adjudication, but it may well be that the parties decide that the best way forward is mediation. I had a case quite recently where the dispute involved a final account with 1,000 or more items, and there were disputes on nearly every one. So the idea of taking that dispute to a formal procedure like litigation, arbitration or adjudication, it made the mind boggle the amount of time and cost. So they decided quite sensibly, in my view, to refer it to mediation, where the mediator is there not to go through every item in the final account, not to get bogged down with the detail, but to say we're trying to get a commercial result here and talk about how you can settle your disputes amicably on a figure which you can both walk away with thinking that justice has been done. So I think that the contract will decide which form you're going for as a first.
That's a compromise, not necessarily justice.
Well, I think you're looking for justice, aren't you, at the end of the day? But justice can sometimes take the form of time. You might get the wrong figure, but the fact that you've got it all over and done with quickly may well be part of the is it just, is it not just?
Okay. So what about case law? Is case law, or has case law ever been drawn upon to actually clarify ADR rules?
Well, it isn't really there to clarify ADR rules. If you take adjudication as an example, since the Act came into force on the 1st of May 1998, there have been a lot of cases. And I think that to some extent clarifies the process. Just to give you an example, is it enforceable? That was the first issue, which the courts got over that very quickly and said, of course, it's because it's the will of Parliament. Then the next thing that comes along is that only construction contracts can go to adjudication, and it defines construction contracts, which is the sort of thing that you would expect. Plus, it said that the contract must be in writing or evidenced in writing. But what's the difference between in writing or evidenced in writing? Well, we had to go to court to decide that. Case went to court involving an engineer who had an appointment, fees about 15,000. There was a claim against him for 600,000. And the argument was the contract in writing? Well, there's no formal contract written, but it was alleged because there were site meeting minutes, there'd been fees submitted, there was evidence of a contract. But the court said, well, no, you've got to have all the contractual terms in writing somewhere for it to be evidenced in writing. The other sort of thing that arises is that can you appeal against an adjudicator if it's manifestly wrong? Well, you'd think perhaps, you and I would say, well, if it's manifestly wrong, surely we can appeal against that. The court said no. Even if it's legally wrong, if it's factually wrong, you have to comply with it because it's only an interim decision. If you're not happy with it, you can then have the case totally reheard in court or in arbitration at a later stage. So they'll enforce matters which, in fact, on the face of it, are manifestly incorrect. So that's just a couple of examples of courts clarifying the adjudication process.
So does this actually really shorten the process? I mean, we were led to believe that this would be part of the end of the litigious society, and manifestly that's not the case. So the fact that arbitration can then be gone through and then reheard in a court of law, is that the way that it was envisaged?
Well, I think that the way that it was envisaged is that the smaller disputes, up to say 100,000, once you've had your decision by a third party, you're going to say, well, I'm not going to take it any further. And something like 90% of the disputes are for less than £100,000. So 90% of that's the end of that. Once you get over £100,000, well, it's marginal as to whether you decide to take it one step further. But the costs are so horrendous. If, for example, you had a dispute for £100,000 and you went to arbitration or litigation, you got an award of £75,000, the cost would probably be up more than that. So less than £100,000, you're not going to bother. Once you get over £250,000, I think you start thinking serious. Over £500,000, you're very serious. Over £1 million, you probably go.
Okay. Well, just in terms of the idea of partnering, which we started with Latham and Egan, we were led to believe again that this might get round disputes. Again, from your innumerable cases, that hasn't happened. So,
well, I think to be fair with partnering, the idea is that you've got better relationships. And there's no doubt about it that if you've got good relations and you try and resolve problems together as you go along, then the chances of having a big blow up at the end are severely reduced. And I think that partnering, as far as that is concerned, has worked. And certainly disputes on partnering projects are very small indeed. And I think if there are disputes, they get settled by a rather different process. They have a hierarchical system where the dispute starts at site level, and if you can't agree it there, within 28 days, it then goes up to managerial level. If you can't agree it there, it goes up to director level. If you can't agree it there, it goes to mediation. So by the time you've gone through that process, most of the disputes have been sorted out. It's only the bigger ones that are likely to go much further than that.
Okay. Well, just finally then, what's new? What should we be all looking out for? There's a number of different forms of ADR which have come to the fore in the last 30 years. Is there anything on the horizon?
Well, I think that one method on the horizon relating to larger schemes is the Disputes Adjudication Board. I was reading about Crossrail the other day. We're talking about 15 billion expenditure, and that's the estimate. And if we compare it with the Olympics, you don't know what it's going to finish up at. A lot of that work will be below ground, so disputes are likely to be pretty frequent. So you need a process of resolving disputes as the job progresses. And if you have a disputes adjudication board, which is popular on international projects, what happens is that the parties, once the contract has been entered into, appoint the disputes adjudication board, either one person or three. And the way in which they're appointed, each party would normally appoint one and the two parties will appoint a third. Now, the nice thing, if you happen to be on the board, is that you get a retainer paid every month. And, but for that, of course, you have to keep yourself up to date as to what's happening on the project. As soon as the dispute arises, you've got a panel there who are fully conversant with the project. You refer your dispute to the panel make a decision, and you've got 28 days to either accept it or reject it. If you reject it, then you can take it on to the next stage. But I feel that that is certainly likely to be the way forward with larger schemes. The smaller schemes, I think mediation, because it's got a very high success rate. If you ask CEDA, they're promoting, they'll say there's 90% success rate, but you're not too sure whether it's 90% in terms of numbers of cases or 90% in terms of value of work that's been resolved in that particular manner. But I think mediation and the Disputes Adjudication Board will certainly increase in size. Adjudication, I think that's really built in now, and as I say, there's something like 4,000 or 5,000 cases every year where an appointing body appoints an adjudicator. So that's going to, if not remain constant, with a credit crunch, it's likely to increase. So I think those are the three. Arbitration, I think, in this country is going to die the death, apart from maybe a few cases, and litigation you avoid like the plague. Could I just give you a quote about litigation, going back to 1700? I brought this because I thought you might ask the question, you see. This is John Pomfret in 1700. He said, "Lawsuits I'd shun with as much studious care as I would dens where lions are." Now, I'm not going to comment on the quality of the poetry, but it does, in fact, express a view which was common in 1700. And if you go into 1800, well, we're probably familiar with Bleak House, which Dickens wrote. And in the 1900s, there was a gentleman who used to walk up and down outside the Strand, outside the law courts. And he had a big banner, and across the banner was written, "Arbitrate, don't litigate." So it may well be that there'll be people with banners now saying, "Mediate, don't arbitrate." But that's the way things progress.
Very good. Well, on that poetic note, there's quite a lot there to digest. ADR, it seems, is as old as the hills, but unfortunately, in terms of time, that's all we have for you today. My thanks to Roger Knowles for coming in to discuss ADR. As always, for more information, take a look at the study notes that accompany this program. And until the next time, goodbye.